We are live. Great. Welcome, everybody, to the first conference committee on genetic data privacy, H.639. And we welcome the House to Senate Economic Development, Housing and General Affairs Committee. Good to have you. Thank you for partnering on so many bills. Thank you for saving Sister State. Very grateful. And today we are beginning our work on trying to come to some agreement on a landing spot for genetic data privacy. And I think it makes some sense for us to begin with your request for us to reconsider what we have in front of us, for us to reconsider excluding genetic material from being able to be cured. And I think because we had included all of it in the 60-day cure period, and you took that back, and you agreed in principle, then you said, we're concerned about genetic data not being able to be cured. So we need to appreciate, or at least understand that better. And I think we're all here wanting to hear that, but also wanting to represent the Senate, our position, which was we really wanted to give an opportunity for things that could be cured to be cured. And if they're not curable, and I think your point is you think some of it is curable if it gets it. So I think the ball is in your court in that.
So when we heard that you didn't want to go to a committee conference, we thought very carefully before this about what we would send to you and that we thought you could concur. And so we compromised significantly in what we sent to you. Had we asked for what we thought, what the House really wanted, it would have been a much shorter cure period. Because we considered a cure period when we were deliberating it and understood that this is the most personal information that it is the essence of a person, right? It is our actual genetics. And so to cure that is really difficult, right? That gets out and that gets out and you can't get it back. And so when you requested a cure period, we said, well, sure, there are things that you can cure. You can cure a privacy notice not being listed the way you want it to be, or not being responsive in a way that a consumer was expecting that you promised them. There are some things that can be cured. A 60-day cure period is not what we would have chosen. Seemed excessive, and so for us it was an incredible compromise to even send you what we sent. So
do we have any questions? Because I guess I have a question, which is, do you have, I understand that theory, you have some examples of damage that was done. I mean, can you give us, illustrate this for us in a way that helps us appreciate it, and maybe in a different light than just abstract or thinking about it, or genetic data?
If even if it's not the genetic data, but it's the report of the genetic data, and it gets out to a data broker, and it gets out in the market for sale, how do you get that back? Right? Once it's so that's something that. You can't cure it. So waiting 60 days to be able to act on something that can't even get back, that has been out in the open market and has been sold. Is that even possible? And why should you have to wait if you're a customer and there's continuing damage? And then what if there's 10 other customers that it happens to after you notified them because they didn't change anything because they could wait 60 days to even make any changes? And so then there's additional harm.
Thomas.
So, great. This is helpful. For me, I'm just not understanding the harm of the cure period. So if they're in that circumstance, or if it was that it went to a researcher, or that it was put to across a international boundary, regardless of what it is, and if it was to a data broker inappropriately, I don't see that we're denying those same rights. What we're doing is we're just allowing for a process to determine whether or not it's incurable without involving lawyers and going to court, but instead, maybe at the end of those 60 days, if that's not exactly resolvable, the consumer that was harmed still has all the rights they had at the beginning of the cure period. Am I mistaken in my interpretation of the cure period? I see it just as a way to resolve the things more quickly, more dynamically, without having to work through lawyers, which can often be much more litigious, much more costly on both sides, and can also delay action. Whereas I feel like the cure period seems to make sense to me, to have time and opportunities for the company to correct things. And then if not, then those same rights, once they still exist at the end of the cure period.
So I guess I'm wondering if you're making an assumption, or maybe it's accurate, that a company isn't going to use a lawyer to fix the problem. Right? Because if they're already going to use a lawyer, then what you're just doing is delaying a consumer's ability to get remediation, and leaving the issue open for more consumers to be harmed and for more consumer data to get out there. Because in a cure period situation, if the business waits 60-day cure period, if the business waits till the 59th day to cure it, then they did their due diligence and they cured it within that 60 days. And so there's an awful lot of extra harm that could happen in that time.
I'm just wondering, with the Attorney General in the room, or a fine representative, of the Attorney General's office, would you, when I needed an illustration, I think Thomas and I are similar in need of a illustration of real harm. I mean, you get to see the real harms in your consumer protection division all the time. What if you could give us a real harm? I mean, 23andMe was a real harm. If we could talk about that, or other examples of genetic data having been sold where it caused real harm, and that where this cure period is for genetic materials would be a problem. That would, I think. Do you understand what I'm asking? Okay.
So Todd Delos from the Attorney General's office. Thanks for the opportunity to talk about it. I think the kinds of harms, so 23andMe is a helpful example because it was all clear and out in the world. As Representative Granning said, what we don't know is how much the data, I don't think we're particularly worried about the genetic sample, the swab, wandering, but certainly that's a concern that's laid out in 639. Maybe the raw analysis of the data, the actual DNA sequencing, maybe that's also really well protected, but it's the analysis therefrom, right? So genetic hereditary diseases, or ethnic or racial information, familial links, and the like. All of that is information that comes from this testing. And as we saw in the 23andMe case, which was a hack, but I think it's important to point out, if the data gets out, this is what happens. So some of the hackers, within hours of getting it, bragged about having millions, I don't know the number, if it was millions or thousands, of Ashkenazi Jew information that was available on the dark web, so that you could connect people, right, to their genetic heritage. That's a concern. I think the Pentagon also warned against using direct-to-consumer testing companies for troops because there were security concerns if certain vulnerabilities were noted. Both of those examples come from the 23andMe data report that was part of the bankruptcy. So those are examples of, do I know what the harm is? Well, what we don't know is where that data went, right? And we don't know what profiling may happen elsewhere, whether it's sort of commercially driven profiling or not, more dark experience. And I think that's what Rep. Granning is kind of pointing at is, are there cases where somebody said this is worth X thousands of dollars or hundreds of dollars or millions of dollars? We're not aware of those. And I think it's really important to recognize we don't know what it means when your personal genetic data that may be, again, a medical condition that is either latent or unknown, or actually known, but you don't want it disclosed, or your heritage information. I think Rep. Shy also in this committee sort of told her life story of finding out, right, that her biological parent was different than her raised parent. She said that all on the record. That may be information she's comfortable with. That I think that was a great story, but there are plenty of other people who, for a whole host of reasons, may not be the legitimate issue of a family. Suddenly thinking about like what it means for all kinds of wills and estates and ownership. I mean, there are a lot of different places where getting that information out there can never be brought back. And of course, reputational damages at least.
And Tom,
So I agree, but what I don't see is how having some time, a cure period, denies any rights or action that they have at the end of it. And the other thing I'd say is, if you start without a cure period, or if there's no cure period on any circumstances, you get the lawyer involved right away. And all of a sudden now the company, if they do take an action to cure, resolve, correct it, I'm wondering if that could be perceived as guilt, as opposed, and then they might be hesitant to actually make the corrective action that a cure period could offer to resolve it in a much more, I'd say, dynamic and responsive manner, being that they do have reputational risk. And if it is able to be resolved because it was an oversight or an lack of clarity, I just see the benefit of a cure period. I'm not seeing the harm of it. Can you help me understand what a cure period would be, who that harms?
Yeah, I'm happy to respond to that. One, and I think as we look at it, there are, and as I think said multiple times to both committees, the main actors in this space are reputable companies. And we don't know all the actors in the space. And the purpose of the legislation is to ensure that this body is regulating that space appropriately with this incredibly important data. That 60-day period, I think this is what Rep. Branning was getting at, was if you've got a 60-day clock, you can sell and transfer and dilute that data for 59 days, 23 hours, and 59 minutes, right? You can keep transferring it. And then the last day say, okay, we've cured it, we've stopped doing it. And all of those transfers beget other transfers. That information goes out further and further and further, right? Now, reputable companies not going to do that. I don't disagree. The other piece, though, that is important, and I think this is something to think about. Well, I guess two other pieces. One, our experience in working in the consumer protection space is a lawsuit's not usually the first step, right? Our CAP program is a great example of mediation and engagement with businesses well before litigation. Some of those instances, I think about half of them, we are not able to help resolve or get somebody to a space where it gets resolved. Those may go to litigation, they may not. But consumers aren't looking to use an attorney right off the bat. They're looking to get recourse. And I will say candidly, absent litigation, sometimes businesses are not that interested in responding. So the final piece there in looking at not just harm, but how business reacts is that cure period is basically, it's a little like arbitration, right? It is not a public process. There's no history of it. So Thomas Chittenden we may be working with the same company and some violation occurs. You go to them and say, fix it. And for whatever reason, they're great. They'll fix yours. Then I figure out, oh, it's happening to me too. Fix mine. We never know how many times that's happening because it's a business process, it's a faulty process or what have you. There's no public element to it, right? And so there is also a degree to which understanding and having, a public understanding of whether a company's following the law or not is valuable.
I just add one other thing, because when you say a person, an individual who is harmed can still be made whole after waiting for 60 days. One of the things that we talk about all the time in this building are the mental health and stress inducers that are happening and all over, right? Because of so many different things. And to have to wait 60 days and know that there's nothing that you can do, right? It happens once you start a process. But once you start a process, you know that it's moving and you can be at least putting your energy into that. But to have to just it on your hand, wait, there are a number of people, and a lot of people are getting this genetic information and the sequence because they're trying to to make themselves whole, to understand different pieces about where they come from and who they are and all of that. And so to put them in a situation where in order to, you can do that, and you would have to, if there's a problem, you just have to sit and wait. It would add significant stress for those.
I do want to follow up.
Okay,
Yeah.
and then I have a question too.
So just on your points there, Todd, first of all, two really. So the 59.5 day example you gave, if they continue to do behaviors that was wrong to begin with and continue to be wrong, at the end of that, doesn't the claimant still have the complaint and that could take them to court saying they were inappropriately sharing this data and that during the cure period, they failed to resolve it. In fact, they doubled down on the behavior. I have a second question.
So I think that would have to be determined through litigation, right? And you'd have to there would be a discovery process that would have to go about. But the point is there wouldn't be cessation at the moment, right? They could be running a risk of increasing damages, certainly. I think there's also an open question about what cure means in the context of this bill. And really, because it's a novel concept in Vermont in consumer protection law, right? And I think you've heard me say it before, but this would be the first time that we're aware of a consumer protection law, including this cure period.
Without the cure period, are you guaranteed a cessation at the moment of the filing? You're not.
You certainly can. I think you certainly can ask for that in your filing, right? That's what a preliminary injunction is. You can request this
Cessation, immediate cessation.
But the along with the derogation of an existing right that consumers have, what is not clear is what cure means. So if I engage with a company and this terrible scenario, which again, I want to be clear, I don't think the reputable companies in the market are going to do it. But if I choose somebody else because I click the link and I really want to do it, right? They continue to sell my data to pick the country on your list that's the most disreputable. And then they tell me we stopped doing that on day 59, day 60, right? And I say, well, it clearly kept happening. And I file litigation. They say, well, no, we cured it. We stopped transferring it within the 60-day window. Right? Is that cured? They stopped doing the violated behavior. Or I say you owe me $10 million. They say we owe you the price of your data testing. We're going to give you that back, and that's it. Is that cured? I think one of the challenges here is absent the ability to go to court, this cure period can potentially prolong and potentially provide a defense for a company to say, no, we cured it. So there are no more damages here.
The last question I had, I promise keep talking.
Okay.
You mentioned about how they wouldn't have the public nature of the filing, but there's no silencing agreement. If you were to issue the statement, they can go public, they can make hay, they can say this is terrible practice.
And they could do it now. That's absolutely right.
So I have an even more early fundamental question, which is, how does an individual find out if their data has been sold inappropriately? I know this is pathetic because it seems sort of modest, but how does an individual even know this? And if they do know it, I mean, we knew it publicly when we had the big breach with the hack of 23andMe. We knew it when we had the other hack which and breach which led us to create the first in the nation data broker bill. I mean, but how does an individual know that their genetic data has been sold someplace else? And how, if it is then sold and it's already out and been sold, let's say, to a bunch of insurance companies, or who now know that I have an incurable disease or I have a genetic disease that will go on in time, and therefore my insurance rates may change. I mean, I'm trying to find an illustration that's a harm, right? So first question, how does an individual even know that their genetic data has been sold? And then second, the illustration of a harm that will have a real either financial impact or a blackmailing impact or a profiling impact that's ugly. I can think of or your genetic data sold to the federal government. I mean, we still have, that's still a possibility here in the middle of this, right away. I mean, this genetic data could be being sold to ICE or to, whoever's, whatever. So those are my two questions. Yes, Dave. I think you're the one in the room who can answer them unless anyone else can.
I mean, one is that there are businesses that will scour the web for your information. You can pay them to be your advocate in looking for information that is, so there's.
So there are businesses that could be acting on an individual's behalf.
Yeah.
That could give you an alert. Okay, that's helpful.
Well, and I have great news. There's a bill in this committee called the H.639
Right.
right? That would give consumers the ability to find out what data is being collected about. Right. Just that simple step in the data broker bill at least enables and empowers people to find out that information. I think that's what.
But at the moment, there's not much. Oh, and Bridget wants.
May I have to, Bridget Moore on behalf of Ancestry. I think that's part of the concern, right? So if you were to get an email about, let's say, something related to your ethnic background, and you assume immediately, oh, well, that must be because I did my DNA test through Ancestry, then you're going to potentially sue Ancestry for that violation. And Ancestry would be in a lengthy legal process and wouldn't be able to confirm whether or not that was because of their mistake. Whereas if you go through a cure period and you notify them, I received this, did this come from you? They would be able to either tell you, no, like, no, we can show you that this did not come from us and you should direct your attention elsewhere. And then you can continue to find the company that may have violated you there and sue the proper company in that place. Or if they can't prove it, you can still go and take them to court.
Okay.
My guess is any consumer in that situation would be sending that letter or having an attorney send that letter to anybody who could have shared that information.
And so if you have a company that, for example, has its own proprietary software to collect cigarette butts, and from that, knowing who was at that place getting rid of cigarettes, deduce that DNA collected that shows that particular profile belongs to one of several individuals. In other words, you can come up with a way to collect the information without being a company that's in the collection business at all.
Yeah, but we're, I think, pretty much just trying
In the legal collection business,
People would assume it's ancestry, but in your case, your example.
you could collect it, or you could be in the business of collecting it and selling it to.
And I think those are the other companies that may be out there that are in sort of, that are,
We
not the three big
that
ones.
we need to regulate it another way.
yeah, that we need our data broker bill for it.
But
It's another reason we need the data broker bill.
I don't know how you file a lawsuit on an assumption without evidence. You have to have
Oh, exactly.
some type of evidence.
Yeah.
You're not just gonna say, oh, I had my genetic data tested by Ancestry. And
Okay, you're never.
now
So
I'm starting to get these.
Right.
These requests because I'm Polish. But there's nothing that's an assumption. I gotta have some type of proof in order to go to court. I don't know if that's really a good
I
example.
just want to throw out one issue that Senator Chittenden and I have a finance committee meeting scheduled right now.
Right.
But to your point, Chair Markoff, is I'm still not seeing how the cure period is harmful, because in your circumstance there, I can see every legal remedy still available to them. Now, 60 days isn't the right number. That's way too long. And although I'm not quite seeing out 59 and a half is really problematic and behavior still inconsistent with what they're allowed to do, I think that's still going to be corrected or so on. But it just seems to me to make it reasonable in this very new space with a lot of different interpretations on these things to give the companies that ability to just resolve it during that time period. And if they fail, then they still get to sue. But that's
I think what I'm hearing, that's the concerns, is that once it's out, I mean, there's no amount of time can cure it, if it's sold and used immediately. So, I mean, I'll use an extreme case.
Sold
Sold, resold. If the genetic data is bought by ICE, for example, and they make an arrest 2 days later and somebody's reported, man, I mean, that's what I know, an extreme case, but that action, I mean, I'm trying to find an illustration that helps us appreciate how immediate that loss is and what ramifications could happen
So
in very short order.
23 needs the genetics, somebody's genetics or genetics get out. well, they did have that. So, I had my genetics tested. I had a marker for some type of fatal disease that I don't even know about, because
Right.
if that gets out and it's bought by life insurance companies, and I applied for life insurance, and they come back and say, you have this marker. It's like, how do you know? Right, I think that's a harm. Now you can't get life insurance. So, I think we need to really think about this. And the other thing we need to think about is we're talking about Vermont consumers that are harmed by a company that is not a Vermont company. Right. I think for us, if we were talking about a Vermont company, we would maybe take a different look at it. But our sole purpose is to protect Vermonters.
Right.
And Vermont companies. And we're
Tom
not
and
talking,
Randy are tired of hearing these.
but we're not talking about a Vermont company.
I just think we need to ground our policies in practice, what's capable and what's doable in the industry. And so hearing from the industry what would work and not work and all of these things and ed tech and all of these topics, I do think it's really important to fit practical legislation. And so I both those examples that you just offered, I'm just still not seeing how a cure period prevents justice.
Kirk, one more comment, and then I think we're gonna have to regather on to.
I mean, one of the things that we hear about are scams. And they're sometimes related to data privacy things. So a number of people have their data bought or stolen. And by an unreputable group that identifies that a certain segment of people have a high probability that they have Alzheimer's. And so now they're going to get a lot of phone calls in the next 60 days, trying to set them up for opportunities to buy the latest thing or help their grandchild who's stuck in Colombia or what have you. And we do hear these cases of where those populations are being targeted. And so if that data is out there, someone can just buy that data. Once it's gone, and so you have a 60-day cure period. Yes, that person, 60 days for them to cure it. But in that 60 days, how many scam calls can your grandmother get? And would that do harm when she gave away the entire farm?
Just not certain action at the beginning to prevent that from continuing to happen.
Just to flip your question, what's the harm in waiting 60 days for something that isn't curable? What's the benefit for waiting 60 days when it's not curable? I don't know that there's a benefit to the company or the individual for waiting 60 days for something that is not curable.
As I thought I said at the beginning, is to resolve the matter with as little resources on both sides as possible to correct them. So as soon as you get lawyers involved and go to the court filing, you have to start working through lawyers and then actions. And this is my impression of the courts. And to be able to maneuver things and actually get things resolved is a lot more expensive and rigid. Whereas I see a cure period as a more flexible time period where things can be adjusted and corrected. But maybe I just need to understand cure periods better.
And I think that's a good question, because what does cure mean?
Well, but if it's not, if the only resolution is for the company to pay restitution, right? Because it is not curable. It is something you can't get the data back. There has been harm already caused. How does it help the company? I can see how it helps the company. It means they don't pay as quickly. How does it help the consumer to be required to wait 60 days? And that I'm not sure there's a good answer for.
It's still getting it in the end. It's just a matter of all the issues that are resolvable get resolved, and then the ones that don't.
Which is the bill that we've sent to you.
Okay, so I think on that note, given that you're on the floor and they're in committee, and I'm in committee, let's reschedule this for Tuesday at some point. And thank you very much. Good start.
So Tuesday,